Hi, I'm Alec Fair and I'm a senior solicitor in the Commercial Disputes and Regulation team. In this section of our video series on handling disputes in Scotland, we look at witness evidence. In Scotland, the general rule is that evidence of a witness is given orally in court, that may either be on oath or with the witness making an affirmation. The solicitor or advocate leading the witness will ask them a series of questions to elicit from the witness the facts supporting that party's case or undermining their opponent's case. As with many other jurisdictions, in Scotland, as a matter of practice, the witness should generally be asked open questions in examination in chief, such as who, what, when, where or how, as opposed to closed questions, i.e. which have a yes or no answer, or leading questions which tend to suggest a particular answer. The other party will then have the opportunity to cross-examine the witness, and during cross-examination may ask closed or leading questions. There will then be an opportunity to redirect the witness on points which came up during cross-examination. As a matter of our formal rules and evidence in Scotland, unless documentary evidence is admitted by the parties for the purposes of the action, someone will need to introduce the document to the court in order to allow it to be formally referred to. This is often referred to as having a witness speak to the documentary evidence. Often this is something of a formality. For example, in a contract dispute, a director referring to a contract which they entered into with the other party and confirming it is the document they signed. In the commercial court, the practice of lodging written witness statements or affidavits in advance in order that the case can be dealt with more expeditiously is well established. The witness statement will generally form the witness's evidence in chief at proof or trial. The witness will usually be asked to confirm the content of the witness statement and adopt it as their evidence, and if there are any matters they would like to clarify. The use of witness statements is pretty much limited to the commercial court and to the family court, but may be ordered in other cases. In commercial cases, a timetable is frequently fixed by the presiding judge, setting out the date on which documents which the parties intend to found on at proof are to be lodged, and also for witness statements to be lodged and exchanged. The prior exchange of witness statements in this way enables parties to better understand the evidence which will be adduced by the other party at proof, as well as helping to narrow the focus of matters in dispute to make more efficient use of court time. This may also help the parties to assess their prospects of success, and in appropriate circumstances may help to facilitate settlement of the dispute. Witness statements should not be confused with precognitions, which are private statements of the witness taken by the solicitor for the purpose of recording what the witness's evidence will be at proof. In civil cases, a party cannot be forced or compelled to give a precognition. A precognition taken privately is inadmissible in evidence, and parties cannot be compelled to disclose the content of the precognition or challenge that their evidence at proof has been different to their position during a precognition. We'll go on to talk about privilege and confidentiality in a separate video. A citation is a formal letter ordering a witness to appear in court at the day and time specified. Serving a citation may be an important tool for witnesses who may be important for a party's case, but for example may be reluctant to appear, or may be hostile in the sense that they might side with or be thought to side with the other party to the action. There are very serious consequences for a failure to attend. If a party refuses to appear after receiving a citation, a warrant may be issued for their arrest. In some circumstances, a party may be unable to attend court. For example, they may be unwell and in hospital. In such a case, evidence may be taken on commission. This is a special hearing where their evidence is taken. For more information on witness evidence, please get in touch.